भारती न्यूज, सीधा, सटीक और निष्पक्ष.
A very good afternoon to one and all present here of the dais on the dais. Bharati Vidyapeeth Educational Complex proudly welcomes you all on the first day of National Seminar on Courtroom to Boardroom Law, Media and Management. We heartily welcome you all to our first panel discussion on the topic, the Constitution as a Pillar of Justice, its role in law, media and management. For this panel discussion, we have Honorable Mr. Justice Hemant Gupta, former Judge Supreme Court of India and Chairperson India International Arbitration Center. We have with us Honorable Mr. Justice Dalita Jasar, former Judge Patna High Court. We also have with us Advocate Pawan Rale, Advocate on Record, Supreme Court of India. Honorable Mr. Justice Ajay Rastogi sir is on the way. He'll be joining us shortly. Thank you so much, the esteemed dignitaries. We heartily welcome you here on this particular first day of National Seminar Courtroom to Boardroom. We are honored to have Professor Akansha Singh, Mentor Live Law, as the moderator for this insightful session. Ms. Singh is the alumnus of the prestigious National Law School of Indian University, Bangalore. She has contributed to the academic growth of numerous LLM students by guiding their dissertation research. Very recently, Ms. Singh worked as a research fellow with the Ministry of Law and Justice. She is presently working as a faculty and mentor at Live Law and guides students in our journey. With this, we now hand over the session to you, ma'am. I request ma'am to welcome the panelists for our panel discussions. We welcome you, ma'am. We welcome all the dignitaries on the dais and off the dais to make this event start. Thank you so much.
Thank you, Jyotika ma'am, for that more than generous introduction for each of us. Good afternoon to one and all, and welcome to Bharati Vidyapeeth Delhi branch. I am deeply honored to be moderating this session based on Constitution as a pillar of justice, wherein we have such legal luminaries of great demeanor, of great stature on the dais with us. Now, before we move ahead, I would like to thank BVICAM for one more thing, that is they have kept this session post-lunch. So everybody is, nobody is empty stomach here, and all of us are fully energized to actually listen to each of the judges. And we have Advocate Pawan Rale also with us, who would be sharing his ideas on media, corporate governance, as well as the concept of law when we compare it and we try to understand it with Constitution. Now, before we delve into our discussion, let me take the opportunity to extend warm welcome to each one of you from the audience, and a special thank you to our panelists over here. We are privileged to have the panel of experts who have dedicated their careers to upholding justice and shaping the future of law in our country. The panelists need no introduction, but I would still do the same. Known for his illustrious career, marked by his commitment to justice, his impactful rulings, and his contributions to shaping the legal landscape of our country. It is my honor to introduce Justice Hemant Gupta, former judge of the Supreme Court of India and the chairperson of India International Arbitration Center. Next up, we have Justice Dharnidhar Jha, former judge of the Patna High Court, whose contributions to the legal systems are not only commendable but are also widely recognized. Now, because I had the opportunity of having a personal interaction with sir, I also got to understand that he is very, very generous. He spoke about being an agriculturist and becoming a judge by chance. So because of his hard work, you can travel from one landscape to the other. That is something that you can definitely take up. Then we have Advocate Pawan Rale, an advocate on record at the Supreme Court of India, whose expertise and commitment to the legal profession is again very widely recognized. You can find his great videos on YouTube also, which are very, very informative, and it is going to definitely help our law students. As you may have noticed, we have a representation of bar and bench both here. So you will get an insight as to understand the completion of 75 years of constitution, how that has stood strong, how the constitution has expanded the legal rights and has tried to help the citizens and individuals within our country. Constitution being the grand norm. How many of you have heard of constitution being the grand norm? Being the most supreme law. Yes? Law students have? Yes. So when we start our preparation from class days itself, sir, we are told about the most fundamental rights. Now, how widely are they actually protected is a discussion that we would like to have today. So very recently, as we understand, if you go on the website of Supreme Court of India, you will read all the relevant judgments which will help you understand the context of today's discussion. So on that note, let me begin our today's session. And my first question would be to Honorable Justice Gupta, sir. As the chairperson of Indian Arbitration Center, how do you see the role of arbitration in resolving corporate disputes while ensuring compliance with constitutional principles of fairness and justice? You can sit there, yes, yes.
The last part of the question first, constitutional fairness and justice. So that is our training is as a student of law. Fairness is inbuilt in you because of the training. You have to be fair and justice oriented. The constitutional framework is always helpful. But in respect of the arbitration, arbitration faces a lot of challenges in the Indian ecosystem for various reasons, including the mindset of the parties and of the entire ecosystem. The arbitration is generally conducted in our country ad hoc. Ad hoc arbitration is where court appoints an arbitrator. And the court appoints an arbitrator by virtue of the powers conferred earlier under the Arbitration Act 1940 and then under the Arbitration and Conciliation Act 1996. The worldwide, except India and maybe in England, the arbitrators are appointed by institutions. There is one reason can be that India didn't have any institution of pan-India status or multiple institutions are there. My institution, which I am heading, is the only pan-India institution established under this statute. The mindset is that we are not tuned up for arbitration by an institution because we have always grown with the idea that arbitration means the court appoint karega to hoga. This is something very difficult. You know, the mindset is the most difficult part to change. You can change the procedure, you can change the conduct, but mindset is the biggest challenge which we are trying to change. How far we succeed, we'll try to see.
Definitely, sir. Also, one of the recent things that I observed that there are a lot of institutions also which are opting for centers for arbitration. Recently, the company secretaries also inaugurated one of their centers. So definitely, the mindset has to be changed, and accordingly, how we perceive arbitration is definitely going to make a difference. Thank you, sir. Moving to the next question, which specifically talks about the enforcement of fundamental rights, sir. So I think you will be the right person to answer this. The Constitution guarantees fundamental rights, but the enforcement remains a challenge. How can the High Courts ensure better access for justice to its citizens?
Thank you, ma'am. Most of us are students. We are also students. Teachers are also here. So we could be having a delineation line of delineation, teachers, the students, and then ourselves, the other set of students. We have two chapters in the Constitution of India. Right from, to start with, if you recall the wording of the preamble to the Constitution, then you will be finding out the setting which is reflected in Chapter 3 and Chapter 4. The Supreme Court, in sum up, earlier the Supreme Court had a refrain that we won't touch Chapter 4 provisions. So as regards to enforcement of those duties which have been prescribed for the states to do in a welfare society, for the welfare of the citizens of India. But subsequently, if I recall correctly, Ratlam Municipal Corporation case, if you read that judgment is one judgment where Justice Krishnaiyer was picking out two articles, 38 and 42. My memory does not tell me wrong. And then there only he was talking of the action to be taken has to be very assertive. And you cannot just deny the benefits of social legislation or social actions on the grounds of lack of knowledge. You all know these things. So Chapter 4, that was for the first time to me, when Chapter 4 was getting recognition for enforcement of a fundamental right. That case is probably the first case. And how the fundamental rights have to be enforced. Yet another older judgment, BIR 1955, Supreme Court 233. That judgment, that is, earlier judgments were judgments which were just tutorial classes. If you are going through those judgments, then you are having a tutorial class feeling. How and what for you are filing a writ for certiorari, how and why you should file a writ of mandamus, and the four writs we have described, which are listed in Article 226 for the High Court jurisdiction. Same jurisdiction will be exercised by the Supreme Court also. Under Article 32, it is a different jurisdiction meant only for the Supreme Court. So it is not that if there are no provisions in the Constitution of India to enforce your fundamental rights. And now, if you want to enforce the Charter of Duties which have been set down in Chapter 4, then also, if you find any part of the state or its mechanics or its limbs violating or neglecting your fundamental rights, then you can very well go to file a writ petition, the appropriate writ petition before the High Court, and in some of the cases before the Supreme Court also. What I want to share with all of you is that the provisions are there. The rights chapter is there, Chapter 3 is there, the directive principles of the state policy is there in Chapter 4. Balancing these things, this Constitution does not say what would be the ultimate to be done by the courts, either the Supreme Court or the High Court. It was the Supreme Court, the earlier Supreme Court, and that is the present Supreme Court is also acting on the same line. It has, because they have set down the precedents in the form of jurisprudence, constitutional jurisprudence. If someone is polluting, that has to be the jurisprudence. How the society has to be compensated, the polluted age. So these are some of the, in every field you have jurisprudence. So the Supreme Court judgments are the ultimate precedents, and they throw the light as to how you have to approach either the High Court, and mainly the High Court, because in one of the judgments, Justice Bharati was telling the Patna High Court. That was PRDA case, Patna Urban Development Authority case, and certain requests were made, because Supreme Court makes the request to the High Court. That is the form of direction. But the then Honorable Chief Justice, who had been my Chief Justice also, and a very respected man, Justice Ravi, he just, through judicial order, disobeyed or just did not follow that direction of the matter was again taken up by the Supreme Court to another commission panel. And they wrote well. The jurisdiction of the High Court is larger than the Supreme Court and the writs. But at least the High Court should have accepted the fact that the Supreme Court is the elder ruler. So its request was a direction to it. So you have such a beautiful jurisprudential law set down by the Supreme Court in all things, be it a business, commercial litigation, a service litigation, a rights litigation, any litigation which you would visualize in the present day scenario. You have a perfect jurisprudential law laid down by the Supreme Court. So there is no, I had the opportunity of hearing you through your question. So the High Courts do not lack the tools which have been told by the Supreme Court in the form of different jurisprudences on different fields. So the enforcement of fundamental rights is not a problem anymore. If one has a real grievance of these rights being improved, denied, or whatever, you very well have to do the High Court. And the High Courts are trained by some of the finest of the brains in the legal field, and you could get the
Thank you so much. As rightly stated by the sir, we have various mechanisms. You have writs, you have PILs by which you can reach out to the court and seek remedy. Now from that comes our next question to Advocate Pillai. Public interest litigations have played a major role in expanding constitutional rights, and we've been seeing a lot of recent updates where it has been said that it is not public interest, rather publicity interest litigation. Also, Justice B.V. Nagaratna has showed concern as to how PIL has to be conceived, and we have to narrow down the misuse of PIL. So, sir, do you think PIL system needs reform to prevent the misuse?
Hello. So first of all, thank you so much for making me the part of this great gathering. Very Honorable Justice Gupta and Justice Jha. After that, coming to the question, it is in relation to the misuse of PIL. But before we go to misuse of PIL, may just take some time actually in explaining how it came into picture. So, public interest litigation, when we talk about, it is a legal action which has been taken in the interest of public. But how the jurisdiction has been widened, because earlier there was a concept of judicial review, and then we came to the concept of judicial activism, and then we have come to the concept of public interest litigation. So if we read all the judgments, including SP Gupta versus Union of India and so on, which was decided by Justice Bharati, and all the judgments of that era, we will find there was one judgment which was cited in almost all the judgment, and which they had to break, and the judgment was of in re side Botham judgment, which was decided by English courts in 1879. Now what that judgment said, and then after that I'll come to misuse of PIL. That judgment said, and in that time 1879, the public law had not come into existence, the private laws were there. So if only that person can approach the court whose rights have been violated, only who has personally suffered the injury, that may be a personal injury or that can be a proprietary injury. Only that person can approach the court. Now, that judgment have to be distinguished, and that judgment have to be, broke by the Honorable Supreme Court. Now, first time when the matter came before the Honorable Supreme Court and SP Gupta versus Union of India, there were 12 different writ petitions filed in different courts. So, it was writ petition number 4, which was filed by SP Gupta, who was an advocate in Allahabad High Court. All the petitions were transferred. And the question was that about the locus standi. So that locus standi ambit, which was decided in side Botham case, that had to be widened. So the court said that any person, even whose fundamental rights are not personally being violated, but even for the other sections of the society, anyone can file a public interest litigation, but subject to definitely proving the locus standi, subject to justify the locus standi. And after that, there were multiple cases. So I will divide the PIL into two categories of cases. First category PILs are those public interest litigations where we talk about that there is a violation of fundamental right. For example, TUDR versus Union of India, which was decided in 1982, Bandhuwa Mukti Morcha case. It was in relation to Faridabad bonded labor case in Haryana. Then there are multiple MC Mehta case where we say that there is a violation of fundamental rights of the people because that was the object of PIL. The second category of PIL, I will divide where the court says that the person who is coming to the court, they are not required to prove that there is a violation of fundamental right, provided it provides or it includes the substantial question of law relating to interpretation of constitution, or it provides a substantial question of law relating to general public importance. Those are two questions which court took into account. So the two categories of PIL. So what happened now when someone files a petition stating that there is a substantial question of law relating to interpretation of constitution, the government comes up with the objection that there is no violation of fundamental right. So first time the Honorable Supreme Court in the case of Ranjit Thomas versus Union of India in the year 2000, it was a case of involuntary resignation which was given by the governors. There was a pressure. So that PIL was filed. The Honorable Supreme Court said no. Even if there is no violation of fundamental right, as the question includes the question in relation to substantial question relating to general public importance, the writ petition is maintainable. Another judgment was in relation to second category, and then I'll come to misuse of PIL. Second judgment was BP Singhal versus Union of India, which came in 2000. It was a case in relation to removal of governors where the Honorable President exercised its power, doctrine of pleasure, and then passed a judgment. Again, the question came that writ petition is not maintainable, the PILs are not maintainable because it has not been filed for the marginal sections of the society. Those governors can approach the court. But the Honorable Supreme Court said no, it includes the substantial question of law relating to general public importance, the petitions are maintainable. Now I'm coming to the misuse. When we come to misuse of the PIL, if we very carefully scrutinize the data, you will find that from 1985 till 2019, I'm giving you the exact data, around 9,23,277 PILs have been filed. 9,23,277. If we talk about only of 2021 data, around 1,10,000 or 1,13,000 PILs were filed only in 2021. Now, what do we think? That these PILs are the rightful PILs? No. If you go to Supreme Court and the High Court, most of the PILs are dismissed because the parties either it reflects the misuse of the PIL. Now, who generally, if you see and if you analyze those PILs, you will find in the second category. That was the reason that I explained the two categories of PIL. That people say that I am not filing a PIL because it is in relation to violation of fundamental right, but for it includes the substantial question of law relating to general public importance. Now there have been multiple instances who are filing these PIL. Earlier the PIL were being filed by NGOs, then advocates. Now there are aspirational PILs which are being filed even by the law students. So there have been, I think there was one judgment decided by my lord in 2020, Umid Singh Chawla versus Union of India, where a person filed a PIL for stopping and closing this Coca-Cola and Pepsi company, and my lord imposed the cost of 5 lakh rupees. And it was well deserved. There are so many judgments. There is a recent judgment where the Honorable Justice Upadhyay, when he took the oath in Bombay High Court in 2023, a PIL was filed in Ashok Pandey, and it was stated that Justice Upadhyay, while taking the oath, did not say I, Devendra Kumar Upadhyay. So it is a breach of oath. It includes a substantial portion of law relating to general public importance and the interpretation of the constitution. Dismissed about 1 lakh rupees cost. There have been multiple examples. People are filing cases for deletion of Sindh from Jan Gan Man, national anthem, and so on. Secular and socialist remove this from the preamble. So there have been multiple PILs. So I think so the reform is required and it will come by the time. I think for now the reform is to impose the cost. If court has come to the conclusion that these PILs are being misused, because even the real people who are aggrieved, even they miss the opportunity because of the misuse of PILs. Thank you so much.
PL was started by Justice Bharati when he was judge, not chief justice, to expand the scope of the expression locus stabilizing. Earlier it was always thought that person who is aggrieved has to come to the court. But he was a champion of the non-total. So he said that the persons who can't approach court can't be deprived of their legal rights. That's how the concept of the public interest litigation started. But may I say that India is the only country which has public interest litigation, no other jurisdiction. And this is one of the abused provision, abused remedy. Instead of genuine people, there is a proxy litigation. There is publicity litigation. I remember there was a writ petition filed against appointment of a judge yet to take over in the High Court. What kind of word we can use is nonsense. How can you file a writ petition against the appointment of a judge in the High Court? That was dismissed by the cost. Service matters, tender matters. Tender matters, the one can understand who is losing, they file a writ petition. But somebody on the street says, in this tender, this is the violation. We have crossed all limits of public interest litigation. It needs to be cut out. That number which Mr. Raleigh has given is actually shocking, I would say, that 1 lakh, more than 1 lakh.
1,17,000
in 1 year. God save us.
May I follow and permitted to say?
Yes, sir. Yes, sir.
I'm not on PIL. My Lord Justice Minda has already pointed out the LSC of not only I must comment the word of LSC, atrocious abuse of the judicial forum, and 130,000 PIL consuming the public cost and public money and judges' time. That apart. Justice Gupta was telling us about the initiation of the jurisdiction in the form of PIL, but I could take you a little bit to different mode of activating the approaching the jurisdiction of the Supreme Court of India. We have Hussain Ara's case. Do you know? Hussain Ara's case cropped up from the cutting of the newspaper. That was from my state here. And another case, Rudal Sah, that also came from the. I had the good luck of being the Minister Secretary of the Bihar State Legal Services Authority. And during my tenure, we have undertaken the visits and the gathering of information regarding the period for which prisoners are in custody. And it was only devastating. If you go through some of the judgments of the Supreme Court, like Rudal Sah, Hussain Ara Khatun, then another judgment, the final judgment in appeal was rendered by me in Patna High Court, Bhagalpur blinding case. Yes. Most of you must not have been born then. and that Khatri versus State of Bihar. These are judgments. I am not on what was the result, what was the issue. The Supreme Court was developing another jurisprudence. That jurisprudence was jurisprudence of awarding compensation for wrongful confinement and loss of life of a person, in spite. Rudal Sah served, had already served his sentence. And in spite of that, he was for 14 years in jail. Hussain Ara Khatun case reveals that there were many prisoners in the state of Bihar prison who have already served, or the minimum sentence which would have been awarded to them, they have remained in custody many more times that sentence. Khatri, someone who was picked up from his house, 20-31 persons, 7 were the victims, and their eyes were told by pouring acid into them. I finally disposed of that in single and the facts are bruised. So those are the real public interest jurisdictions developed by the Supreme Court, where you are coming up with the cause of another person who has been victimized, who has been made to suffer, and whose freedom and liberty have been trampled, abused. So, you must be the academics, especially, and us also, Sida versus state of Maharashtra. Children, child labor. Then Badua Mukti Mazdoor. These are some of the cases. A.K. Roy, Ram Manohar Lohia.
So last year, Sukanya Shanta judgment.
And Ram Manohar Lohia versus SDM Baksar. Those are the cases which all students of law must go through. So that you could have the vibe of how the administrative powers were abused to trample the, snatch the liberties of general citizens. And how the Supreme Court developed the jurisprudence faced with those views. Thank you.
Thank you everyone for answering that question. Now we'll again be asking you, sir, Justice Gupta, with the rise of social media and specifically because we are targeting media here in our discussion, so how do you think that the court should be addressing defamation and misinformation while upholding the constitutional freedoms?
Difficult question. The fact is that Article 19(1)(a) gives the right of free speech and expression. Subsequently, 19(2) puts restriction.
Welcome, Honorable Justice.
First of all, I'm very sorry that I'm late. I can apologize for it.
You all can, please.
So, the right of speech is actually 19(2) gives power to the state to put restrictions. 8 conditions are there. But citizens have also some duty not to offend. I will give you just 2 examples, recent examples. One is Ranveer Alabadia. The kind of joke which, according to the joke, was actually insane comment. Now, the Supreme Court came heavily on the Ranveer Alabadia. The social media is up, says no, it's interference on the right of free speech. You know, every right has some limitations, some decency. You can't say something which are not said. And he copied it from an Australian TV show. Our sensitivity is very different than what the Western world has or the America has. You know, under the guise of freedom of speech, you can't say anything and everything. Like, I will give you an example of the constitutional bench dealing with same-sex marriage. It may be good in concept in USA, in other countries, but India is not right for that. India is not suitable. Although we have copied blindly the Western countries and the American countries, but our societal norms are very different than what the norms are provided by, are created for the American citizens or European citizens. I give you another example. Recently, one of the spokesperson of the party commented upon Rohit Sharma. That is a left. Look, does it affect the right of Mr. Rohit Sharma to say that who is she who is commenting upon him? And actually, Sunil Gavaskar has rightly pointed out that it is not in a beauty show. So, if somebody has to be perfect body, one would go in a beauty show, not in a on the ground. You have to see his performance as a team leader, as a sports person. So this and her comment was that I have exercised my right of free speech. Free speech doesn't mean that you demean the other person. That's not enough. And after the match was won, she commented quite favorably towards Rohit Sharma.
So very recent and very helpful example for us to understand that when you study Article 19(1)(a), you also put a lot of emphasis on 19 Clause 2 because that is where all the reasonable restrictions have been laid down. Okay. So now before moving ahead, I would like to introduce Justice Ajay Rastogi sir, a respected and distinguished member of the judiciary, famously known for his unwavering dedication to the rule of law. We welcome you, sir. And with that, I would like to ask you next question, sir. With the increasing intersection of technology, corporate law, and constitutional rights, how can the judiciary ensure data privacy and corporate accountability?
You see now, this is a complete new segment, a new regime. If we go back 20 years down the line, you had never heard. After the digital media has entered into the real, all these things have come forward. And when you intersect with the corporate governance, you have to see the constitution in particular in the first instance. Let us go back to Article 19 and 21 also. If we read both articles together, it gives you insight as to how the ease to do business can be there with certain restrictions. And when you say about corporate governance, in my understanding, is now on a very large spectrum. In every walk of life, you will come across corporate governance one way or the other. And I put one is CSR. Corporate's responsibility now. This is one of the segment of the corporate governance which every corporate has to follow and every corporate has to look into forward and what is my responsibility to the society. It's not your aim that I should only earn money. Now we want that, like Mehrotra said, when you have constitutional rights, you have constitutional responsibilities also. Same is the governance here. You have the rights, you have the duties. All those who are the corporate sector, they have a duty to see that every sector, every social responsibility must be taken care of. That, to my understanding, is synchronizing the constitution with the corporate governance. And you are asking for digital media.
Yes,
Data. You see, nowadays, scenario has completely changed. We had a matter going on just before us itself about data protection. Data is not protected here. In WhatsApp group, data is elsewhere. Now, if you ask for data protection, it has to be protected because my rights over the data cannot be diminished, cannot be ruled out. But as on today, the law on the subject is not that clear as we are expecting for. But by passage of time, we might get that particular protection laws which take care of my rights of privacy. But data is concerned by and large with the privacy rights. And with the digital media and data protection, they have to be on the same part of the coin. To my understanding, the laws are still in the pipeline to come forward with the objections coming from the public, how we have to proceed in regard to protection. Thank you.
Highlighted by sir, definitely the laws are at nascent stage right now, and hopefully constitution would be helping in guiding and to understand how the direction of law should be moving forward. Now, due to paucity of time, we will be taking up our last question, and all the panelists are both requested to answer it. Arbitration is increasingly being promoted as an alternative to litigation in India, and we would want our future generation also to be promoting ADR more and more. So, how does the constitutional framework support the growth of arbitration, if at all there is any provision, any judgment that you can quote? And what are the legal reforms that are needed to enhance its credibility? Justice Rastogi, Justice Gupta, and Justice Shah.
Credibility of whom?
Of arbitration, if it has to be enhanced, because we understand we are institutional ad hoc arbitration. Yes, sir.
My Lord Justice Gupta should take up the question because why not heads the institution?
Let us have our view point in whether Gupta will put because he is chairman of the IIC.
We are back in
IIC. Arbitration is an alternative. You will find Section 89 after the amendment was made. There are so many alternative mechanisms to follow. The beauty of arbitration is that it is the parties-driven procedure. Parties make selection which person should arbitrate. So they have a complete confidence about impartiality, about his approach, about his knowledge of the subject, and both parties feel that whatever the verdict will come from him, subject to rights available under objection of 34 or 37. They take very binding us. So let us proceed. Like in judicial courts, you will find that if matter goes to jurisdiction of a particular judge, parties doesn't have a choice. Whosoever he may be, the parties have to get their matter identified by that very person. Either in the High Court or the Supreme Court. Party doesn't have a choice. If matter is listed before me, you don't have a choice that asking that, oh sorry, we don't want judgment from you, let us send to the other bench. You can't do it. But in arbitrations, the people decide. So this is party-driven procedure. Evidence and other CPC provisions are completely relaxed. So you have to choose your own procedure, which you want to follow, obviously in the interest of justice and fairness in the procedure. Now, you said about the integrity and all.
Yes, constitutional framework.
Fair. There are amendments going on in 23 of arbitration, which are not still finalized. And those amendments, my understanding, will certainly make the system more perfect, more transparent, more better approach. From some corners, you might be coming across some complaint somewhere about the manner and the procedure of arbitration being adopted. But my request is only one. Any system you adopt is not perfect. Every system has aberrations. So we should not abstract aberration as a basis to see the foundation of arbitration. But we see arbitration in a total scenario. To my understanding, as we are into the arbitration now, I find it is more perfect, better, fair, and transparent in approach. And this journey of arbitration in times to come, to my understanding, will become better than the judicial approach which is going ahead in our country. Thank you.
This is a subject which has just cropped up after the passing of the years. And my experience as an arbitrator, not as a judge, as an arbitrator, is quite substantial. What I could find was that the parties are not fully sensitive to the procedure and the purpose of it. Alva Justice Gupta was telling us at the very outset that the mindset is not there. So what is the mindset? The sensitivity lacks. If you are an advocate representing one of the sides to the arbitral proceedings, then what you tend to do? You understand the procedure. You understand the implications of the procedure. you understand the limits the Arbitration and Conciliation Act has put down upon litigation. And you cannot exceed those things, but still you adopt the civil court litigation procedure. This the advocates shall have to give up. The parties have to, of course, decide the procedure, and my Lord Justice Rastapati has just pointed out. But principles of justice are still there. CPC not applicable, Evidence Act not applicable, but you cannot throw away the principles. So, within the principles, you have to appreciate the duties of the parties and your own duties to minimize the time frame. So as to, the purpose was to cut down the litigation time and make these things easy for the commercial, corporate sector or corporate disputes. And that is the reason that the Commercial Courts Act also says that you refer the matter to mediation and then to arbitration. So, unless the advocates train themselves as to what they have to, how they have to approach the entire issue of the arbitration, and then why their clients to come to the most narrow working agreement, things will be very difficult for them. Extension of time and this and that. Why? If the parties are ready to cooperate with the arbitrator, then it could be disposed of in a maximum period of 3-4 months. 3-4 months. Because you file the documents are bilateral mostly. You file the pleadings, they are there. But just you go through a simple procedure of reviewing the documents or marking the documents, setting down the issues first, and then hear argument and write down the word. But advocates linger for, I cannot go beyond that for what purpose. Thank you.
All of you must have heard the maxim, justice delayed is justice denied. That is the procedure, that is the timeline which generally is taken by the civil court. Access to justice is also a fundamental right. So, arbitration is supposed to be speedier remedy, although in some cases, exceptional cases, it takes a long time. But if access to justice is a fundamental right and the arbitration caters to that segment, then we are in tune with the constitutional values. Thank you.
Thank you everyone from the panel. Now we'll be taking up questions from our audience. If any of you have any doubts, you can please make use of this opportunity and ask. Ensure that your question is related to the discussion.
Firstly, I must compliment the audience is mostly girls. It's nice to see that listening to the discussion.
All students, yes. So can I ask a doubt then?
Yes.
So this will be related to the judgment that we are expecting any time would be coming related to the Gayatri Balaswamy case. What are your opinions on Section 34 Arbitration Act, sir? Should we allow the power of modification to the court, or should that not be so done?
As you have said,
we
better wait for the judgment.
Okay. Alright, yes.
I have no difference.
Okay, please, sir.
Well, my view is not going to be affected by judicial verdict at all. See, if you take a procedure as a civil procedure court, the first court opinion goes to the second court, either appeal or by other remedy mechanism. It goes further remedy for either a revision or the court, second opinion. That is the civil procedure. When you come to 34, subject to what my lords will express their view on the subject, we come across with experience that there are 7 issues raised for adjudication in arbitration. And arbitrators decide those 7 issues. Now you are in 34. where objections are there. Very limited scope of interference. But out of 7 issues, if the court dealing with 34 finds 2 issues have not been properly decided, or it is off the context decided, the whole award is refused. So my view is, if you don't find justification for 2 issues out of 7, you may make an observation for 2, but rest 5 for there is no objection, let that award continue. Otherwise, what is happening is, parties come to the court arbitration, consume time, with the hope that they will get some justice somewhere. Now, those issues where there is no deliberation, no objection, either party is not having any reservation, and still the award in substance goes because 2 issues are not being decided by the arbitrator according to the 34 jurisdiction. So, my personal view is that let 34 be given open for the authorities who they were dealing with. If they want to modify, let it be modified. But award as such must not be set aside on this ground. Otherwise, it frustrates the rights of the parties because you can't go up for adjudication again. Review is not permitted. You can't say, sorry, alright, let me have arbitration again. You can't do it. So, rights of the parties has to be crystallized rather than frustrated. Subject to what by lords in the pending proceedings of the Supreme Court decide.
Let me, because Brother has opened, let me say something. My view is very different. No, the section 34 jurisdiction is not an appellate jurisdiction. There you examine the merits of the controversy. Your objections are to be decided within the 4 corners of section 34. Patent illegality is the only ground, the largest ground. Otherwise, fundamental policy of public law, otherwise, the grounds are substantial. But patent illegality is the ground. If we give power of modification of the award, that there is no limit to what extent the power will be exercised. If power of its interference is exercised, probably no award is going to be maintained all at once. It will be supervisory jurisdiction, it will be appellate jurisdiction, which the court will exercise under section 37, which is not the purpose of the Arbitration Act. Finality of the arbitration award, that is the hormone. In some cases, if you find that the illegality, let it be set aside. The parties have chosen their arbitrator and the arbitrator has not gone in the rightful way, the party will face the consequences. We can't do it. Thank you.
Thank you to both Justice Ajay and Justice Gupta, and again we have a conflicting opinion here. So now I'll be going to the closing remarks. We truly had a very insightful session discussing and covering the concept of media, corporate governance, as well as the concept of PIL that we have discussed, and arbitration as well. We have understood how the Constitution helps in shaping our legal system, safeguards media freedom, and also guides corporate governance. I would like to extend my sincere gratitude to our esteemed panelists for their valuable contributions. I would also like to thank BVIMR for organizing this discussion, which has helped us explore the challenges, the triumphs, and the ongoing dialogue that is so there with regards to the ever-evolving Constitution. And also, lastly, thank you to all of you for your patient hearing and for your active, passive participation. Thank you all of you. Yeah, if you still have any questions, feel free. We have a very generous panelist.
My request to students. Yes, we want interaction with you. If you find that the subject before you have a different question, please ask that question also. Whatever is vague to you.
Good afternoon, sir. Myself, Nandini Agarwal. Since ma'am asked the question on social media platform, my question will be on similar grounds that we can see that nowadays we can find lots of cyberbullying on YouTube channels or Instagrams and all. So how can the justice system ensure that strict cyber laws are enforced to reduce those things?
You are right. The cyberbullying, deepfake, they are the new malices. And when they recently in Ranveer Alavadia's case, the Supreme Court commented upon it for framing a law on that, the regulations. The social media or the were vocal against the honorable judges that it is an interference on the right of free speech and expression. So that, but I think something is required to be set, some regulatory authority, somebody who can oversee some content and take an action. Courts is not a remedy for, as we know. Courts will take time, defamation and other things, but there should be some in-house mechanism somewhere. And the people say that it's a government control thing. So if government control is a misnomer. The government doesn't have any personal interest. It's only the officers appointed by the government take care of the particular situation. Somebody has to take care. You can't appoint the regulatory body. Man can't appoint, we can't appoint. But somebody needs to appoint, and it is the government alone which can appoint. So therefore,
my request is different, slightly different. May I put a question to the students here? What you understand with your knowledge of a subject of law which you are going ahead at the present, what is the parameters of free speech and expression? You find somewhere judgments are there. Few judgments are there. Still, there can't be guidelines laid down for the purpose of to follow. It's a society, it's a culture. Like my brother has said, what is acceptable in the US is not acceptable here. What is acceptable in Europe may not be acceptable to our country. So we have to see in the perception of what our culture is, what is kind of our society is, what is the background in which we all have been developed. We have a mindset. So we have to put our guidelines to follow. Like hate speech. If you go to hate speech and have chat GPT, you will find different expressions. Hate speech is not acceptable. Now, but the question is, what kind of a speech we consider to be hate speech? To my understanding, which is not openly acceptable to the society at large, to which we represent, is a hate speech. But still, it's a grey area. How long the law will be able to deal with the situation? Let us wait for the timing to. But Alavadia is one person who has come forward, the other person is also coming forward. Their speech is not acceptable, society respond to it. Sometimes the society is not responding. Hate speech for you may not be hate speech for me. Regular authority, once constituted by the government, law come into place. There may be a possibility that by judgment law on the subject, keeping our societal changes, may prescribe to some extent as to what is the hate speech and what speech and expression is acceptable in our society.
Thank you once again to all the panelists and our audience. Thank you so much.